the murky waters of the Insurrection Act. Let's dive into it. A lot of people have been talking about the Insurrection Act after the Supreme Court said in Trump v. Illinois that Donald Trump had improperly invoked 124063 in order to deploy the National Guard. And because he had not met the precondition of sending regular military forces in order to enforce the laws of the United States. So that's how the Supreme Court ruled on that. This opens up the possibility that Donald Trump may use the Insurrection Act to overcome the Posse Comitatus Act, which prohibits federal government from having federal troops in states for law enforcement purposes unless authorized by Congress or the Constitution. And in the Insurrection Act, the Congress explicitly authorizes the president to invoke the Insurrection Act. But the problem with the Insurrection Act is that there are a bunch of words that really are not defined as one would have to follow that definition. Like the Britannica Encyclopedia defines insurrection as an organized and usually violent act of revolt or rebellion against an established government or governing authority by a group of its citizens or subjects. So we have a common law, regular definition of insurrection. But there are so many words that are not really definable in the context of common law, and I'll read them out to you. And that, as it stands now, the president has the power to assess whether these conditions are met or not. So, Title 10, Chapter 13, Sections 251 through 255 is what is the Insurrection Act. It's a set of statutes. So, I will read the statutes out to you and point out where I find them to be problematic. So, this 251 is about federal aid for state governments. Whenever there is an insurrection in any state against its government, against the state's government, the president may, upon the request of the legislature or of its governor, if the legislature cannot be convened, so here in 251 you need the governor's consent, you need the governor to request federal troops, call into federal service such of the militia of the other states in the number requested in that state, and use such of the armed forces as he considers necessary to suppress that insurrection. So that's pretty clear. The precondition there is that if there's an insurrection and the state determines that and asks for federal aid. Section 252 says, whenever the president considers, and this is where it gets a little gray, right? Whenever the president considers that unlawful obstructions, combinations, or assemblages or rebellion against the authority of the United States makes it impracticable to enforce the laws of the United States in any state by the ordinary course of judicial proceedings, he may call into federal service such of the militia of any state and use such of the armed forces as he considers necessary to enforce those laws or to suppress the rebellion. Here, it rests upon, 252 rests upon the president's determination that there are unlawful obstructions, combinations, assemblages, or rebellion against the authority of the United States, not the state where it's happening, of the United States. That makes it impracticable. You have to define impracticable. What is impracticable? To enforce the laws of the United States in any state by the ordinary course of judicial proceedings. That would happen, say, by, the judge would give the order, the federal marshals and the authorities in that court would carry out that order. And when that is impeded, when that is obstructed, if there are assemblages, and they are unlawful, the president can deploy. So you have to come up with the definitions of what is an unlawful obstruction. Because as it stands now, state police officers and local authorities are helping federal agents facilitate their federal tasks without going into whether their federal tasks are unconstitutional or not, which in many cases they are, because they're denying every person that they're detaining the right to due process of law. And we're seeing that happen with the dozens of habeas petitions and with the dozens of other cases coming up. And that is what we are seeing in the court before the invocation of the Insurrection Act, that Donald Trump's DHS, not regular forces, but his civil enforcement forces are carrying out these duties, and they're not being obstructed. They're actually being facilitated by the state here. Then you go to Section 253. The president, by using the militia or armed forces or both, or by any other means, shall take such measures as he considers necessary to suppress in a state and any insurrection, domestic violence, lawful combination, or conspiracy. So you have to define insurrection, domestic violence, unlawful combination, and conspiracy. You have to define them in order to see that those preconditions have been met. What is the domestic violence? What is the suppressing of the violence in the state? And in Section 1 of 253, it is about the state refusing to follow federal law. So hinders the execution of the laws of that state and of the United States within that state, that any part or class of its people is deprived the right, privilege, immunity, or protection named in the Constitution and secured by law, and the constituted authorities of that state are unable, fail, or refuse to protect that right, privilege, or immunity, or to give that protection. So this is when states refuse, or states are unable to fulfill a federal law, or unwilling to carry out a federal law that is tied to the Constitution. And at the end of Section 253, it says, any situation covered by Clause 1, the state shall be considered, so the state has to be considered to have denied the equal protection of the laws secured by the Constitution. That is under the 14th Amendment's due process clause. So the Insurrection Act builds into it the mechanism that's saying that the president may go into states and enforce federal law that the states are unable or unwilling to enforce. And that happened during the desegregation of schools in America. Section 2 says, when he considers necessary to suppress in a state any insurrection, domestic violence, unlawful combination, or conspiracy, if it opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. So there has to be an impediment. There has to be an obstruction, an opposition by presumptively the state entity in order for Donald Trump to invoke the Insurrection Act under 253(2). But again, the states and local authorities are helping Donald Trump's troops, federal agents, in carrying out their duties, even though these federal agents are violating the constitutional rights of the people who are being detained. Section 254 requires that whenever the president considers it necessary to use the militia or the armed forces under this chapter, he shall, means he has to, by proclamation, immediately order the insurgents to disperse and retire peaceably to their abodes within limited time. So this is about giving notice before actual deployment of the troops. Somebody commented on my Trump v. Illinois video saying that the mayor of Illinois has made it impracticable to enforce the laws of the United States and is not allowing federal agents to enforce the laws of the state. That is incorrect. That is false. First of all, the mayor of any city, local government, or state government does not have the power or jurisdiction to enforce federal laws. That falls on the shoulders of federal agents. And as we have seen over and over in the states, whether it be states suing Donald Trump or not, that local authorities are facilitating federal agents and making sure that they keep the peace between the protesters and the federal agents when the federal agents are executing the laws of the United States. So there's no showing of an obstruction, an assemblage, a rebellion, a conspiracy, an unlawful combination. None of that is present. And those are the preconditions that Donald Trump needs in order to be able to deploy the troops to states under the Insurrection Act. And because of the murkiness of all this of these words, the Brennan Center writes, Congress should amend the Insurrection Act to define more clearly and precisely what situations may trigger it. Congress should also establish mechanisms to review the president's decisions that will guard against abuse while still preserving the president's flexibility in the crisis. In the meantime, if the Insurrection Act comes before the courts, judges should determine, as the Department of Justice has in the past, that the law is limited by the Constitution and tradition. Something very important here, Donald Trump doesn't give a hoot about our traditions, and he very clearly doesn't give a rat's behind about the Constitution, because his federal agents are violating the Constitution left, right, and center by depriving people they detain of due process of law. How do we reconcile that? That Donald Trump's forces, his civil enforcement forces, are violating constitutional rights. It's not the people who are attacking the government. It is the government that is attacking the people, and that itself is another topic altogether. As aside from the Insurrection Act, but the Constitution governs everything. You have to know this. So when somebody deprives you of your constitutional right against unreasonable search and seizure, against not being Mirandized, not given assistance of counsel, not given a speedy trial, not given notice, not given these basic due processes that are required by law under the Constitution of the United States, those are violations for which these people have causes of action against the government, because the government itself is violating the Constitution. And that's separate from invocation of the Insurrection Act. The Insurrection Act invocation depends so heavily on Donald Trump's definition of all of these different crises that may develop, that gives him the right to invoke the Insurrection Act. He has to prove those preconditions first exist. And as it stands now, those preconditions do not exist. With that said, thank you for listening. Please remember to like, share, and subscribe, and I'll talk to you soon. One more thing. Section 255, the last part of section of the statute, says that Guam and the Virgin Islands will be considered states under this statute. So it extends the jurisdiction of the Insurrection Act. It doesn't have anything else to do with the substantive part of the law. So thank you for listening, and I will talk to you soon.